Hello, I'm Susan Ingles with South Carolina Legal Services. In this presentation, we'll cover some frequently asked questions about the Fair Debt Collection Practices Act. So what is the Act? It's a federal statute that regulates debt collection. It covers primarily debt collectors, so not the original creditor. So, for example, if you have a hospital bill and the hospital is calling you trying to collect it, that kind of collection activity would not be covered by the Fair Debt Collection Practices Act. However, if the hospital then transfers that debt to a debt collector for them to try to collect it, then that new entity is covered by this act. And we call it for short the FDCPA. It has three purposes: eliminate abusive debt collection practices, protect legitimate debt collectors from the unfair competitive advantage of those who engage in bad practices, and then just to create a uniform body of law to govern the behavior of debt collectors. So what types of debts are covered? Well, consumer debt, such as anywhere from credit card debt to student loans, finance company loans that are being collected by someone other than the finance company, car loans, medical bills, and so forth. Business debts are not included. So how about debt collectors contacting you? Can they contact you anytime they feel like it, at any place they want to? And the answer to that is no. The Act covers a number of items there. They can't contact you in all hours of the night or repeatedly during the duration of one single day. They can't come to your place of work if you have notified them in writing not to. But otherwise, they can call you, send letters, any of the methods of communication that we have in the modern era. So what can you do to stop a debt collector from harassing you or contacting you? Sometimes people think their only option is to file bankruptcy, and that's not the case. You can send a written letter under the FDCPA to a debt collector and directing them to stop contacting you by any method of communication, to stop coming to your house or your work if they're doing that. This is sometimes called a cease and desist letter or a no contact letter. The only thing you need to know about taking that kind of action is that typically the next thing that will happen is the debt collector will move on to other forms of debt collection, such as filing a lawsuit against you. So contacting other people about your debt is prohibited. They can't discuss your debt with anyone but you. And sometimes you might have someone listed on a loan as a reference or something like that, and they might get calls. Well, that's not allowed. The only thing that a debt collector can do as far as contacting a third party is to try to find you. So if you're still living at the same address as when you signed up for this debt, then they don't need to be calling anybody else. Now, if you've moved and they're not able to find you, then they do have the right to call one time to find out a phone number, address, etc. So the debt collector does have to give you a validation notice about the debt that they're trying to collect. Just how much do you owe, the name of the creditor that you supposedly owe it to, and what to do if you think that it's not a debt of yours. So what if you don't think that it's your debt? Well, then you can send a letter asking for verification. They have to verify by giving you all the information that they have within 30 days. Then you can hopefully make a determination if it is your debt. Now, the Act prohibits debt collectors from doing certain things, and these are just some examples of that. I've broken it down into the three broad categories of they can't harass you, they can't lie, and they can't engage in unfair practices. And the biggest one that we see is threatening people with jail or letting them think they might go to jail by using suggestive language. You can control which debts your payments apply to if a particular debt collector is collecting more than one debt from you. So then maybe you send a cease and desist letter, or maybe not, but the debt collector has sued you. What should you do? Well, you need to answer the lawsuit. And this is something that quite often we find people don't do for any number of reasons. It might be they're just scared of lawsuits, scared of going to court. They don't know what to do. Maybe they think they don't owe the debt, and so they'll just ignore the lawsuit, and that won't make it go away. Or they might think, well, it's the statute of limitations has expired, or maybe they've paid the debt. But you've got to file an answer that raises that with the court. It's important for the court to know what your defense is. Otherwise, they don't know, and they're just going to ultimately give the debt collector a judgment for whatever they ask for. Can a debt collector take money from your paycheck? No, not in South Carolina. We don't have wage garnishment for consumer debts here. And to find out more about wage garnishment in South Carolina, you can go to our website, which is shown on the last slide of this webinar, but it's www.sclegal.org, and that website has a number of our brochures, and one of them is specifically about wage garnishment in South Carolina, which is very limited. So what if the debt is old? We often call this time-barred debt because in a typical situation, for example, a credit card, the debt collector, the creditor, has 3 years to file a lawsuit to collect the debt from you. If they don't do that, they no longer have the right to file the lawsuit. Now, during that 3 years, you have to have not made any payments. So it's 3 years from the date of your last payment, essentially. And keep in mind that if you make a payment during that 3 years, that restarts the statute of limitations, and so the 3 years will start over again. And we sometimes see debt collectors trying to get a consumer to just pay a little something as good faith. You'll just pay $5 just to show your good faith. Well, that's not really good faith. What that can do, if you're not careful, is start that statute of limitations all over again. So a debt collector can contact you about that debt, even if their right to sue on it has long since expired, because you may still owe the debt even though they can't sue you over it. If you're not sure whether your debt is time barred, you should contact the creditor or whoever the debt collector is, or when they contact you, find out what they show as the last date of payment, and then you can backtrack through your own records with your bank account. How about your credit report? If a debt is time barred, can it still be on your credit report? And the answer is maybe, and quite often yes, because negative information is going to be on your credit report for 7 years. And just because they can't sue you on it doesn't mean that you don't still owe it. So your credit report may very likely still show that debt, and it's not required that it be removed just because the statute of limitations is expired. Now, do you have to pay it if it's time barred? Well, it's up to you. As I said, you may still owe the debt at that point, if you determine that it's yours. So you have some options. You can pay nothing, and they can't sue you, but they may still try to contact you or call you, come to your house, and so forth. So that may still continue unless you send them the letter that we talked about earlier, the no contact letter. You can make a partial payment. But keep in mind that if you do that, you may start that statute of limitations all over again. So if you're going to do something like that, you may want to consult with an attorney and make sure that your rights are observed. Thirdly, you can just pay off the debt. And in fact, some of the debt collectors will accept a payment that's less than the full amount that is owed. But again, if you're going to do that, you do want to consult with an attorney because you're going to want to make sure that you have the proper paperwork that shows that settlement agreement and that it's reflected properly in the federal court. If you don't do that, you may find yourself being pursued by yet another debt collector on the same debt years down the road. If you're sued for debt where the statute of limitations has expired, you still need to respond. Again, you can't say to yourself, oh, well, 3 years has passed, so I'm not even going to answer that lawsuit because I don't have to. Well, you have to raise that issue with the court again so that the court will know what your defense is, because the court has no obligation to look into that on your behalf. And where should you report violations of the FDCPA? Well, you can report them to the Federal Trade Commission, the Consumer Financial Protection Bureau, and here in South Carolina at our own Department of Consumer Affairs. And I would urge you to see our webinar on the South Carolina Consumer Protection Code for more information on that. What else could I do if I think a debt collector has broken the law? Well, you can actually sue the debt collector yourself. You don't have to wait for them to sue you. If they've violated the FDCPA or any other law, you have the right to sue them and go ahead and bring that lawsuit. And under the FDCPA, you need to think about that because there's a 1-year statute of limitations for you to sue under this act. And you do have the right to seek damages if you've incurred any, ask the court to assess statutory penalties against the creditor, and even pay attorney's fees and costs. You can find out more with online resources that are found at the Federal Trade Commission, ftc.gov, the Consumer Financial Protection Bureau, consumerfinance.gov, and the South Carolina Department of Consumer Affairs at consumer.sc.gov. You can contact us here at Legal Services if a creditor is violating or has violated the act and you want to get some information about what your rights are. You can apply for our assistance by telephone or online. And if you have been sued by a debt collector or creditor, you typically only have 30 days to answer, sometimes less, and that is considered an emergency, so you can, if necessary, apply in person at one of our local offices. I also encourage you to check out our website at lawhelp.org/sc, where you can find materials and resources on this and other legal topics. Thanks for watching.